Move on to the seminar, the conference proper. And we begin with panel 1 entitled The State of Philippine Legal Education, a National Situation Report. May we call on the Dean of the College of Law of Lyceum of the Philippines University and also the Executive Vice President of PALS to introduce our esteemed panelists for the first session. Dean Saludad Derriquito Mauis.
Honorable Judge Patrick Cantilo, to his left, Mayor of the City of Love, who gave us a very serious challenge to empty our wallets before we leave the venue. And therefore, this is one time where we have to rise to the challenge. Attorney Rose Setias Reyes, President of the LEB of the Tibet Patriotism, Dean Nilo Divina, President of the Philippine Association of Schools, Dean Ernesto Macedo Jr., Chairman of the PALS, distinguished panelists who will be properly introduced later, deans, professors of law, special guests, ladies and gentlemen. May I especially acknowledge and mention the three deans of the host colleges, Dean Pauline Viñol Alpuente of the College of Law of Timna University of Iloilo, Dean Jose Marilyn Terol of the College of Law University of San Agustin de Iloilo, and Dean Zacarias Binoda Jr. of the Central Philippines University. We thank you so much for hosting this conference this morning. May I also acknowledge the presence of my friends, Justice Goa Victorino of the Philippine Christian University, Justice Portia Gutierrez of the University of Visayas, and my colleagues in the appellate courts 1 century ago. Although our Master of Ceremonies a while ago already mentioned the members of the Legal Education Board, I want to reintroduce them with a very brief statement of their basic credentials so that you may know them, considering that these are new members of the Legal Education Board. There are two members who are present today, and they are Dean Fe Año Nuevo and Professor Manuel Riguera. Dean Fe Año Nuevo finished her law course at the College of Law of Adamson University, cum laude. She is also a Doctor of Education, which she earned from the University, De La Salle University. She has been Dean of the School of Law of the Philippine Cambridge College, a Professor of Law, and a practicing lawyer. As already mentioned a while ago, she represents the Philippine Association of Law Schools in the board. Professor Manuel Riguera graduated his law course at the College of Law of the Ateneo de Manila University. He is a professor of law and a practicing lawyer, and he authored 2 books, a 2-volume reviewer on remedial law. He is also the director of the Youth Jurist Review Center, and he represents in our board the Philippine Association of Law Professors. The two other members of the board who are not present here this morning are former Court Administrator Zinaida Lepanyo and Dr. Carmelita Yagaw Sison. Former Court Administrator Lepanyo finished her Bachelor of Arts course at the University of San Tomas valedictorian summa cum laude, and Bachelor of Laws from the same university valedictorian cum laude. She was a three-time bar examiner, a professor of law, and a professorial lecturer in the various NCLE seminars. She represents the integrated bar of the Philippines in Iran. Dr. Carmelita Yagaw Sison represents in the board the chairperson chair, who is an ex-officio member. She is a Bachelor of Laws degree of the College of Law of the University of the Philippines, Master's degree in National Security Administration from the National Defense College, and Doctor of Philosophy. She was the first woman General Counsel of the University of the Philippines. And now my panel presentation. As Chairman of the Legal Education Board on an extended term of office, I am happy that the Philippine Association of Law Schools continues to partner with us. And even if it may not always be possible to concede every request that PALS makes, the Legal Education Board certainly puts a premium on very constructive working relationship with the association. Amendments to Republic Act 7662. The Legal Education Board was taken by surprise when we were furnished a copy of House Bill number 4736 that seeks to amend Republic Act 7662, creating the Legal Education Board. The House Committee on Higher and Technical Education requested the presence of a member of the board at its hearing some weeks ago. We requested through Congressman Roman Robo, the chairman, for time to submit our comments. We did on July 23. I would like to share with you, my friends, our comments and suggestions. The Legal Education Board fully agrees on and recognizes the necessity of amending the enabling law, which RA 7662. This law was enacted in December 1993, and for one reason or another, it lay dormant for 16 years, until in 2009, the Legal Education Board was finally constituted. We have repeatedly talked to you about the first difficult years of the Legal Education Board and the difficulty we had in weaning law schools from the judge dependence. There, however, have been significant changes in the landscape of legal education that necessitate amendment of the law. First, among these is the fact that RA 7662 has patent deficiencies. Even the enumeration of the membership of LEB is not consistent. There are also ambiguities in respect to membership. For example, a student member. When a student member is appointed and he ceases to be a student, either by graduation or by the termination of his law studies, is he still eligible to sit as member or not? While it might seem like the easier answer would be to go with the term of office as set forth in the appointment, it happened that the appointing power set no term. And it can also happen that the student member ceases to be a student while in mid-term. His continued membership would then contravene the purpose of having a student member in the board. Second, there has been a dramatic increase in law schools from 59 to 124. On the other hand, this is a step in the direction of accessibility. One thrust of higher and professional education in the country is access. It is not right that the professional education should be available only in the metropolitan center of the nation, where the cost of living are high. One salutary development in legal education is the growing number of law schools outside Metro Manila, which have attained a degree of excellence comparable with the best law schools in the National Capital Region. These include the law schools of the University of San Carlos and the University of Cebu in Cebu City, Ateneo de Davao in Davao City, Xavier University Ateneo de Cagayan in Cagayan de Oro, and the University of San Agustin in this city of Davao. Other provincial law schools are about to join this group of top-rated law schools. The increase in the number of law schools exacts of the LEB more thorough supervision and ampler forms of assistance. In this respect, I would like to assure you that as LEB chairman, imposing sanctions on law schools has never been as distasteful to me as it is to you. I had thought that the more constructive thing to do is to help law schools, and this is the reason for our periodic visits, as well as the seminars for law professors and deans. I also wish to assure you that we will abide by the Constitution that directs that state reasonable recognition and supervision over institutions of higher learning. Control is alien to the LEB's concept of regulatory authority. Third, the experience of the past year gives us a vantage point from which to propose amendments to the existing law that created the Legal Education Board. I have been blessed to work with very dedicated and professional colleagues on the board who have taken our mission to heart. It is also my privilege to have the assistance of very competent and dependable staff, namely Mr. Rodrigo Salgum, Ms. Rodrigo Nieve, and Ms. Catherine De Castro. They are here. But it is also apparent that given the number of schools and the task of a regulatory agency, the diminutive staff we have at present is unable to meet the challenge, heroic efforts notwithstanding. Fourth, there is the challenge of ASEAN integration. As the Philippines strengthens its position in the regional community and makes borders and boundaries less important than they used to be, legal education cannot be insulated from this change. If anything, it must be the model of integration in higher professional education in the ASEAN region. Among the matters we ask Congress to consider with the following. Number one, the removal from RA 7662 of terms or provisions which give the impression that LEB is dependent on CHED and therefore an adjunct of the latter. Although the leadership of CHED recognizes and respects the autonomy of CHED, of LEB, of which we are grateful, there are still a good number of schools and law administrators who, because of those terms and provisions in the law, seem to consider LEB as an organic component of CHED and therefore deal with it in the course of the operation of the law program. There is therefore a need to excise from the law those terms and phrases that cause this aberration. The intendment of Congress is clear that legal education should be subject to a distinct regulatory regime that attends to the peculiarities of the schools. I can, however, fail to commend yet again CHED for its cooperation to the regional seminars of LEB in many regions. CHED officials went out of the way to arrange for LEB seminars. We have here with us today Dr. Casimple, who represents the CHED region in space, and we are very grateful for all the assistance given to us by the region. Number two, Section 4 does not include as a member of the board a representative of the Philippine Association of Law Professors. But in Section 5 of the same House bill, it appears that he is so. This inconsistency should be corrected. Number 3, we also suggested that a 10-year teaching experience requirement for members of the Legal Education Board should be maintained. Because in House Bill pending in the House of Representatives now, it lowers the teaching requirement from 10 to 5. We are urging them to restore or to maintain the 10-year teaching experience to be a member of the board. One who sits in the board must have an exhaustive exposure to legal academia. And we feel then, as we do, that the purposes of the law would be better served by members of the LEB who have had longer experience in legal academia. Of course, 10 years of teaching in a continuously mediocre manner would hardly help. But all things taken equally, a professor who has been teaching for 10 years has a reservoir of insights and realizations to draw from that one with only 5 years does not have. Number 4, one reason why I remain in office on holdover capacity, despite my age of 83 and my general weakness, it is because it is so difficult to fill the vacancies in the board with the present requirement that the law prohibits LEB members from the practice of law. This has discouraged many otherwise qualified members who have had so much to contribute to legal education, but were both loath to abandon lucrative law practice. We have therefore proposed that while members of the LEB be allowed some practice, they should nevertheless be allowed, they should not be allowed to teach so as to rise above the suspicion of partisanship or undue favor. 5, we have proposed that members of the board sitting as representatives of one sector may at the end of their terms be endorsed and appointed as representatives of a different sector in any organization, especially those vested with regulatory authority. Institutional memory is very important, especially with those vested with regulatory authority. We have made suggestions, other suggestions, and one of them is the increase of the budgetary allocation of the Legal Education Board, which is even less than the budget of an ordinary barangay in Metro Manila. Towards quality assessment and voluntary accreditation. LEB, heeding the clamor for legal education that does not hinge on bar examination results alone, would like to develop a system of quality assessment preparatory to voluntary accreditation. We are building from the ground up, for as you very well know, we have already declared some law schools as centers of excellence in the past, namely University of the Philippines, Ateneo de Manila University, San Beda College, San Carlos University, Ateneo Davao, University of San Tomas, Arellano University, Xavier University, University of San Agustin, and Palestine University. These are the first 10 top-rated schools which were granted certificates of excellence. I wish to point out, however, that the status of Center of Excellence is not some ornament of institutional vanity. It is a mandate to be a partner of LEB in the upping of the quality of legal education. Centers of excellence are truly excellent, not when they keep their strength to themselves, but when they become centers for the development of other law schools in this environment. Seminars held together, in-service training programs that are open to the law professors of other institutions, invitations to students of other law schools to participate in academic and co-curricular activities of centers of excellence are some of the effective ways of keeping with the ancient maxim, bonum diffusum sui, excellence will then diffuse itself. But I now call on those schools that were identified as centers of excellence to meet and, by coordinating with us at LEB, form quality assessment centers or teams. These quality assessment teams will then visit those schools within their clusters, not in a manner of supervisors checking the accomplishments of subordinates, but in the concept rather of willing partners, able and eager to extend assistance in the common quest for excellence in legal education. Eventually, it is my hope that from these quality assessment teams, there shall arise a system of voluntary accreditation. The fear has been articulated among even some members of the officers of PALS. The only legitimate aristocracy in the world, according to Chief Justice Fred Ruiz Castro, is the aristocracy of the mind. All over the country now, in all other courses and programs, there are voluntary accreditation schemes under the Federation of Accrediting Agencies of the Philippines. Why should we in legal academia believe that we cannot be advantaged by the adoption of a similar scheme for legal education? Countryside Legal Seminars. Since we last met, the legal education has invested its effort of updating and upgrading the competencies of legal educators. This is the reason we have a series of seminars on ASEAN integration in legal education. I gratefully acknowledge here the participation of the following lecturers in seminars of the same nature, namely Dean Nina Divina of UST, Dean Merlin Magallona of UP, Dean Senfred Candelaria of Ateneo Law School, Dean Ranjita Aquino of San Beda Grad School of Law, Dean Manuel Jokno of De La Salle University, Professor Karen Meno of UP and San Beda Grad School of Law, Professor Juan Lago of the University of San Carlos. We thank them all for their help and assistance to the Legal Education Board. There is one thing that I would like to remind you. We have had some a few cases in the board involving complaints of students against the law school administrators. And all because of the failure of the law schools to manualize their policies and rules so that the students would be informed right from the start when they enroll. And so that when there would be violations of these policies, they can be made accountable. They are bound by this policy of the school. But they can be bound only if they are notified. And the first time that they should be tried is at enrollment. Because if there are policies which are not properly disseminated to the students, and these policies are violated by the students, they will become accountable. So my advice is, put all these policies and these rules in a handbook and then serve on the students upon enrollment. Curriculum revision. I would want to put on record that the Legal Education Board is not only open, but in fact a promoter of curricular revision. We realize that the curricula for Bachelor of Laws and Juris Doctor that we prescribe in LEB number 1 can no longer address the different problems and developments that have since appeared in the landscape of legal education. And therefore, well, a month or so ago, I brought this idea to Dean Juan. And I told her that we are about to constitute a panel of curriculum experts to craft a more responsive curriculum for the law subjects. But they requested me to suspend the constitution of that panel to await the result of a survey that's ongoing. But according to Juan just a while ago, they are done with it, and they will give me the results of their inputs rather, by September. You can be sure, therefore, my friends, that in the month of November, we shall constitute the panel of experts in curriculum to formulate the curriculum which will be submitted to the board for approval. And I hope that you can give in your inputs to this panel so that if they are found to be good ones, they will be incorporated. And finally, my friends, we shall celebrate the 5th anniversary of the Legal Education Board on November 11 of this year. And the highlight or the centerpiece of that anniversary celebration is an awards night where we shall award the 10 outstanding law schools based on the performance in the bar examinations for the last 3 years. And also to give recognition and medals to the 10 top-notch, the first 10 top-notchers in the bar examinations of 2014. Without prejudice to a formal invitation to you, I am now inviting all of you to attend the program. Remember, it is our 5th anniversary, and therefore we shall expect you. We love to see you there. Thank you so much.
With a quote from James Moliterno, a professor of law at Washington University School of Law, the author of The American Legal Profession in Crisis. He said, "This is a great time to be a legal education reformer. And I've been singing that tune for 30 years. This is a moment when everybody is listening. I'm a really happy guy right now." You know, legal education reforms are not novel ideas. Educators have long pushed for legal education reforms, but it's high time to act and to implement. Just for information, in 1976, Justice J.B.L. Reyes. In 1980, former C.J. Fred Luis Castro. In 1989, the 1999 Judge Herrera. 2002 Judge Mendoza. All of them, one time or another, led initiatives for legal education reforms as well as bar examination reforms. In fact, in 1999, because the passing rate was 15.99, the lowest in history, the Supreme Court commissioned or directed Supreme Court Justice Herrera to do a study on legal education reforms to explain the reasons for the dismal passing rate. And as I mentioned, in 2002, Justice Mendoza came up with specific suggestions on how to improve legal education as well as the bar examination. My take is, it's now time to act, time to implement. The essential part of these reforms is knowing and acting on the challenges facing law education or legal education and those principally tasked to administer the law needs. Let me start now with the challenges. I divide into two: traditional or customary challenges and recent challenges facing LOD. The first one, maintaining enrollments in the face of stiff competition and escalating costs. In the States, there has been a decline in application for law by 40% since 2002. In the Philippines, surprisingly, there's an increase of 3.57% every year. But I foresee that because of escalating costs, there may be a decline in application for law admission. And of course, you have stiff competition. Based on statistics, 700 students on the average go to the top 5 law schools. The rest go to the province, with Region 7 accounting for 12.7% of total number of students, which at this time amounts to 40,000 students more or less. So Region 7 includes Cebu and Iloilo. The question is, what is the minimum number of students for a law school to be viable? The problem is, many of them would like to go to top law schools. Now, why do they go to the top law schools? Because they're perceived to be the top. So the best students go to the top law schools, and the top law schools are able to maintain their being top because the top students go to them. So the challenge is, how do you convince those students to go to your law schools? Sometimes we compromise admission standards to get students. Because without students, there are no tuition fees. It's the lifeblood of law school. Without tuition fees, obviously you have no funds to finance operations, to pay your professors, to improve your facilities, so forth and so on. But if you have less enrollment, how will you survive? What do you do to attract not just the best, but the students from other schools to enroll in your university or your own college of law? So chicken and egg thing. In my own, I did a survey, pardon me for using this as my example, and this survey was a good friend of mine from Ateneo. I did a survey. In UST, the top students of UST, AB and Commerce go to San Beda, Ateneo, and UP. Because these are the top 3 law schools in the country. But if I'm able to arrest the exodus, if I'm able to snatch them away from the top 3 law schools, then the improvement in the bar will likewise increase. So the challenge for me, and perhaps the challenge to you also, is how do you attract the students to go to your own law school? Later on, I'll give you some suggestions. Some may be revolutionary, as you will note, but suggestions nonetheless. Second, getting quality students and adopting an efficient and objective elimination process. Now, last semester, I recruited a very good professor with excellent, sturdy qualifications. I assigned him to my honor section. He failed 1/2. It's my honor section. He failed 1/2 of my students. 10 cum laudes, 2 magna cum laude. Undergraduate students. And I know, and I asked myself, did I make the right decision in recruiting this professor with excellent qualifications, impeccable, sturdy qualifications, but to flank my potential bar top-notchers? I did also my own study. If I will limit my examinees to the top 50%, then I can probably make Ateneo, San Beda, UP, and run for the money. But the key is, how do you make sure that all your top students will take the bar examinations? You need to have an objective and efficient elimination process or criteria. Next, improving the skills of students. You know, we are trained not to have or acquire lawyering skills. Our students, rather, are trained to absorb data, information. They're required to read cases, to memorize. But they're not required, absolutely, to have lawyering skills. And I have heard many times my students, now lawyers, sir, I did not listen to this, I did not know about this, I did not learn this in law school. And I only learned 10% of what now I know in practice. For example, motion ad cautelam. Does it ever exist in the rules of court? No. Many of the motions being filed in court are not in the rules of court. And a student of mine asked me, sir, how come this motion is not in the rules of court? Because I said you can think of any other motion as long as it's left to the discretion of the court. Omnibus motion. Omnibus motion containing 4 to 5 motions. No? Is that in the rules of court? Again, no. So, according to a study by US University, too much emphasis is placed on results of the bar examination. But, do you know that in USA, bar examination performance is only 10% of total criteria? There are many other criteria like admission rate or job opportunities for graduates, rejection rate, quality of the professors, quality of facilities. Again, in the Philippines, we put too much emphasis on the results of bar examination. So our curriculum is dictated by the bar examination such that there's little room left for our students to acquire learning skills. They're forced to memorize. They're forced to absorb data because this is what will be asked in the bar examinations. The challenge then is how do we improve their skills? How do they acquire learning skills? Not just the capacity to absorb data and information. Next, please. Recruiting and keeping qualified faculty. I always believe that there are three elements for a successful law school: good students, good faculty, good facilities. And not necessarily in that order. Dean Danicon, another good friend of mine, told me once that UP College of Law tops the bar in spite of the professors. That's what he told me. They top the bar in spite of the professors because they're very good students. Now think of it this way. You have a good chef but stale food ingredients. You will not have good results. You have excellent food ingredients but lousy chef, it will also not work. It must be a successful combination of good chef, good raw ingredients, and good kitchen equipments. I think same with law school. Good students, good faculty, and good facilities. But then, how do we keep them? First, we recruit them, and the second, how do we keep them? You know, one professor, an expert in commercial law, quit teaching after 25 years because he felt like he was just parroting the provisions of the law. If you've been teaching for 25 years, I assure you, you can conduct your lecture even with your eyes closed. Try it. The best way to be an expert in any subject, teach it. You're not knowledgeable in remedial law, teach it. After 3 years, you become an expert in remedial law. Commercial law was not my favorite subject in the bar. Commercial law was the least favorite topic in the bar. And you only appreciate commercial law when you become lawyers and realize there's more money in commercial law than any fields of law. But I was poor in commercial law, and I taught commercial law, and now I can recite decisions of the court in commercial law. Because the best way to be an expert is to teach. So we have to recruit the best, but how do you keep the best? If you get bored, you get jaded after 25 years. They need to motivate, as we'll explain later. Next. Alright, motivating, I think I have mentioned that. Oh, sorry, just an anecdote. When you come to think about it, let's say a professor gets paid 1,200 pesos per hour. I think that's the highest. I think Ateneo pays 1,200 per hour for professor. It's not a trade secret anymore, it's a trade. But what about a successful practitioner who can command 10,000, 20,000 pesos per hour? You do your math. 10,000, 20,000, as it is 1,200. Easily, they will never be paid to law practice, right? So how do you motivate them such that they will forego 10,000 pesos per hour in exchange for salary reward? It may be 1,200, maybe 500 pesos, no? But some things in life can be bought by money. And that's what you have to sell to your professors. Next, please. Adequate funding, managing costs, and securing position support and management. Every year, all of us, I'm sure, present our budget to management, right? Every year. They scrutinize our budget, and if you have good PR, no questions asked, your budget presentation will probably be approved. And if you are in good grades, you can ask whatever you want to ask. But if you're not in good grades, time to rethink, time to reconsider. Not to quit, of course, because quitters never win and winners never quit. Reconsider in the sense that how do you get them to approve your proposal? More of that later. It's not enough to have, as you know, tuition fees are not enough to run or fund the law school. we should have or get support from our alumni. And this is is something, what do you call it, a bold statement to make, but I think that the LEB should not accredit any law school if there is no funding support from management. Or let me put it positively, the LEB should require management of law school to commit funding for the school or the college. Otherwise, it will not be accredited. And of course, Judge Larry is listening. I got his attention. So LEB perhaps should direct all law school, management of law school, the owners of law school, that we will not accredit you, and you can never be university or law school unless you commit to fund your law school. Minimum, more than the budget of LEB. More than 10 million pesos. So I thought it's a bold statement to make. Next, please. Efficiency of law school management. First, load distribution. What happens if somebody approaches you, a very good professor, Dean, I would like to handle this criminal procedure. But you're loaded with judges who want to handle criminal procedure. But this professor is one of your assigned professors, but not teaching that subject, and the other professors are not so good raters, but have been there for many years. So how do you efficiently distribute your load? And corollary to that, monthly non-performers, how do you break the news that the rating is unsatisfactory? How do you say in a nice way, I'm sorry, Justice, you have no load this semester. And I'll give you tips later on. I think the most important part are the tips, no? The suggestion, not the challenges. I'll mention an anecdote. You know, in UST, if you don't perform, you don't get outstanding rating for 3 semesters, you're given the boot. If you obtain only 3 satisfactory performance for 3 semesters, you should be asked to teach another subject. So one of these professors got satisfactory rating, but not outstanding for 4 semesters. And I thought I should talk to him. I said, Justice, I think you better cut out for this subject. I think it will be more effective if you handle this subject as compared to your present subject. And I tried to say it in a nice way, as nice as I can. The politician in me coming out, you're better or cut out for this subject rather than this subject. You know what? He didn't accept it. And he talked to the priest, to the rector, to the Dominican fathers, no? I have been ostracized. No? I have not been given load by Dean. I have been supporting him all these years. No? And I felt so bad. No? And all I want is for the good of the university, the College of Law, and his own good. And I tried to soften him. I tried to cuddle, no? His ego. But you know, babe, later I'll tell you how I did, how I went about it, and got him back to teaching UST. Submission of grades. It's a common problem for all of us, right? What do you do if a professor is delaying submission of grades? And he's an outstanding professor. It's easy to say, get rid of him, right? But what if he's the only expert in that subject? Then you become a hostage, you become a hostage to this professor. And you know very well that in case of delay submission of grades, your enrollment gets delayed likewise. And if the enrollment gets delayed by a day or 2, especially those in the province, the following day, onslaught social media attack. The following day will be in social media, criticized, crucified, pilloried, that the enrollment process is not effective and efficient just because one professor was delayed submission of his grade. How do you handle this? Talk about that later. Something common to UST, San Beda, Ateneo, UP, and other law schools, fraternities, and sororities. Trust me, they also quarrel. So it's not limited to fraternities, but also to sororities. And there's a way to handle this, as we will see later. What is the ideal term for a law dean? Is it 3? Is the current practice? Is it 4? The full cycle? Is it 5? Just like USA, so that you know the results after 4 years? In the Philippines, it's 3 years, right? Is it ideal? 3 years, not or short for a good deed, but too long for a lousy deed. So what is your preferred or ideal term for a low deed? Succession. When I say succession, I don't mean transfer of ownership because of death. When I say succession, let me mention it, let me cite this example, anecdote, no? College of Music, so there was a presentation to the academic senate, the senate composed of of deans of the universities. So we wonder how come this professor was there in USC College of Music and now 82 years old, no? So we asked the dean, how come we have no successor? And he said, no, we have successor, except that everybody wants to enroll in the subject, it's so good. No? Now, what if your expert in civil law is 85 years and he has not trained any understudy or prodigy? How do you handle that? We will not be here forever. So Benjamin Franklin was correct. There are only 2 things certain in this world: death and taxes. No, I take back, just death. Because tax can be avoided if you have good lawyers. But death cannot be avoided. We will all die. It's a question of when, where, and how. So we need to have succession plan so that younger professor can take the place of your old quote-unquote experts. For the next 2, performance of bar examinations and job opportunities for graduates. Then recent challenges. Number 1 is adapting the demands of ASEAN integration and globalization, and marking the image lack of enrollment by 2020 due to the K-12 enrollment educational program, and then the social media onslaught, coping with technology advances, and lastly but not least, and I say it as soft as I can, dahil ang logo, requirement of obtaining a master's degree in law as directed by LEB. Now, my proposed solutions. The first one, how do you make enrollment in the face of state competition and escalating costs? Try to adopt the blue ocean strategy. What is blue ocean strategy? Not to compete with the best, because they're 10 to 20 years ahead. Instead, carve or create your own niche and attract those inclined to your niche. For example, you want to be best in taxation, then you hire the best taxation professors. So those who are inclined to be expert in taxation will go to your school, even though you're not the best overall. Or you want to be good in corporate finance, then get the best professors to handle corporate finance. So you'll be known as the best law school in this subject. So you create your own niche, and you attract those interested or like to have a career in corporate finance, or tax, as the case may be. And then second, letter writing to the top graduates. I do this every year. For the past 6 years, I write about 1,000 students, suntok sa buwan basis, no? So, inviting them to enroll in UST with offer of scholarships, book allowance, housing subsidy, with the wish and expectation that if the 1,000 students, 100 are minded to take up law, and I get 30 or 40, then I'll be happy. So 1,000 letters every year, 100 will respond. Of the 100, I get 30, 40, not bad. Next, offer scholarships, book allowance, housing subsidy. The only way you can arrest the exodus to the top law schools, you offer them incentives. And I'll cite you an example. It is now raised now among the top law firms in the country. So we made our own offer sheet to the top graduate of a university or a college of law, and our offer was higher than the top law firm in the country. But the top law firm in the country gave a signing bonus of 1 million pesos. But when I did my math, 500,000 pesos. When I did my math, 500,000 divided by 12 is only 5,000, right? you add 5,000 to the offered salary of this law firm, it's only about 31,000. Higher than the offer of another law firm, but this student went to that law firm. What's my point? My point is you have to offer something new, something distinct, something novel, something earth-shaking. Scholarships, housing subsidy, book allowance, no? Because they're not being given by your top law schools, because they don't need to quote-unquote bribe the top students, because they go to them. So you need to get them by motivating them to enroll in your law school. And you, of course, you have to get the donors to fund your scholarship program. How do you get the donors? Get the top alumni and name the scholarship after them. Let's say the Juan de la Cruz Foundation for Educational Excellence. So forth and so on. You get your top alumni, get it to commit 500,000 every year, you have 5 million pesos. With 5 million pesos, you have so much to work on to be able to get the top students. Second, adopting an efficient and objective evaluation process. Departmental exam is not a bad idea, I tell you. So UPNT has departmental exam, second-year students, no? In our case, for the first time, we are adopting a departmental exam in all bar subjects. How does it work? There will be common questions for all students. And what is the rationale? The rationale to to eliminate subjectivity and ensure objectivity in giving grades to our students. Let's say you have 4 professors handling persons. Then they will submit 5 to 10 questions to the chairman of the department, and the chairman will now choose 5 questions from the 10. So each professor will submit his own questions, no? So a pool of questions will be asked to all the students taking the particular subject. They will be encouraged now, if not forced, to be expansive in their reading. They will not be limited to the materials or notes of the professor. Instead, they will be required to read more, just like preparing for the bar examination. Now, what about the booklets to check? Who will check the booklets? They also. But don't give them their own students. Otherwise, tendency is to jack up their grades, to convey the impression that these are the better students compared to the others. But don't give them also the students of the other class, because the tendency may be to put them down, to bring out the best for the other students to do well. So there will be a mix of their students, no, and students of the other class without them knowing. So this way, you will be objective and you will be subjectivity in giving the grades of your students. And then second, I think this is adopted by many law schools already, adopting a reasonable quotient point index or QPI. A minimum grade before they progress to the next year level. Okay, what about variability? Supposing 1/2 of your students don't meet the QPI, what happens now? You may want to adopt your QPI on a yearly basis, not on a semester basis. Because by semester, you will have a significant drop in your enrollment. So in UST, for the first time in our history, okay, part of the example, for the first time in history, we have 730 students, the largest. Because we do our debarment every year, not every semester. Another issue is to give them more time to look for other law schools. If you depart them towards the middle of the semester, middle of the year, they will find it difficult to look for other law schools. So that would be a yearly or annual basis. Next is to remove security of tenure. Now, when I say security of tenure, I don't mean employee-employee relationship. I mean, this I think practice is better. Even though you reach 4th year, you can be debarred. In many law schools, now once you reach 4th year, you cannot be debarred. You have to take security tenure. But the tendency is, once they get security tenure, they become lax. So eliminate security tenure, so let them work for it until they graduate and take the bar examination. Third, on improving the skills of students, I suggest you have essay writing competition, get the best paper in each subject with token incentives. For example, in UP, they ask students to write and give awards for the best paper in constitutional law. So I didn't contest paper in constitutional law, this also paper in commercial law. I think all subjects. I'm not sure if Teneo is doing the same thing, but something we may want to emulate. So require the students to write paper in criminal law, civil law, commercial law, and award the best paper for the particular subject with token cash incentive. And then next, top third-party providers. You know, we're not experts when it comes to training, right? We need to tap other providers like Center for Global Practices, My Legal Wish, and so forth and so on. So, for example, Henry Kende, the owner president of Center for Global Best Practices, he has this program, improving the memory of students and how to excel the bar examination. So we will run, I think Johan will also run the same seminar in San Carlos. That's what Henry told me. And I have to swallow my pride because the one who will give the lecture is a top-notcher from San Beda. So San Beda law graduate, top-notcher, will teach UST on how to tap the bar examination. Because we have no monopoly of talent, right? We have to get the best talents from everywhere. Those we need to help. And we can tap, as I said, third-party providers. Recruiting and keeping qualified faculty. I suggest you do a survey on top faculty in the country. Do a survey. Ask around. Ask our deans. Ask PALS. We have a department, as you know, experts in particular subjects. So ask, do a survey, and then recruit them. If you can compete in terms of monetary benefits, offer something unique. For example, again, let me mention this as my example. Pardon me, because I have no other example to make. So this professor is an expert in labor law. The problem is he's teaching in UP, Ateneo, Isabela. He's not teaching in UST. And the salary in Isabela, Ateneo, higher than salary in UST. So I have to say, Professor, you pray and represent the Benedictines, the Jesuits, the laymen. What about the Dominicans? Don't you want to complete the package so that you can get a slap in heaven? So I appeal something else. I offer something unique, and miracle upon miracles, he has start teaching USD this semester. So you have to offer something unique, a unique proposition to them, so that they will consider teaching in your own law school. And then regular fellowship. It did not be expensive. I think I got this from Ateneo, so this makes the point to meet this faculty every so often. And that's the beauty of having many friends, law dean's friends, no? I get the best practices. Yeah. We compare notes. I get the best practices from Ateneo, from UP, from San Beda, and I'm sharing them with you. Because in PALS, we care for one another. So regular fellowship, for you to meet your faculty at least once every semester, minimum. You don't have to talk about serious stuff, just pure and simple camaraderie. Bonding moments, they say. Next, motivating the faculty and ensuring commitment towards teaching, including your budget cost of faculty development. It's not so much anyway. We did our numbers, so faculty development of this nature, you don't spend 500,000. So if you have 2 seminars every year, that's only 1 million, something that you can easily sell to your management. And then set high standards, challenge them, and make them feel they're part of something novel. And then come up with a pool of researchers to assist the faculty to get updated research students, and lessen their burden. And this is what they've been doing in PALS. No? Because our professors are very loaded. They have their, they have their own practice, they teach, they do other things. So in PALS, we noticed that we established a pool of researchers, the best students in the country, and we require them to prepare diaries of cases. We of course give them token incentive, and we disseminate these students to all ODs. And we started doing this last year, and we're doing it again this year. So this is something you can also do for your top students. No? This is the initiative of PALS. Get them to digest cases and distribute the same to your professors. So you help the students at the same time you help your professors. Adequate funding, managing costs, and security support for management. Gone are the days where offices of deans are palatial. It can be small, but elegant. And I say this to my good friend, Dean Santa Maria. Because I think we have a new office, no? I took pictures of my office and I'm going to share it. So I read an article that our offices need not be big. It can be small but elegant, tastefully decorated or done, so that you can reduce your cost. And then hire faculty on contractual basis. This may be a bold statement, no? If you can remove student tenure, better. But if not, hire faculty on contractual basis and do away with the cost of having tenured faculty. And then, of course, take advantage of online instruction. It's almost free. If you can get the best professors because they're busy with other law schools, get or take advantage of online instruction. And then to also obtain or secure alumni support. On efficiency law school management, on load distribution, I think I have given my example earlier. You may want to consider this. Let's say you cannot say no and you have security tenure. You may want to limit number of students attending his class. At least you contain or minimize the quote-unquote damage, right? And then you ask your top students to enroll in the other section, no? So limit the students. Because if you can get rid of it, is an institution, no? But let the damage be contained or minimized, right? And it can be further mitigated by your departmental exams. Because they would have to make up for the inadequacy or deficiency of that professor. On submission of grades, you may want to consider this. A default passing grade. So tell your professors, if you have submit your grades, I will give your students a default passing grade of 75. Without prejudicial adjustment once the grades are submitted, but no downward adjustment. I checked the rules. We had the discretion to give grades to the students in case of delay. But of course, if it's on time, we have no power to change the grade, right? But if there's delay, a reasonable delay, we have the authority to give a default grade. So at least you will not delay your enrollment. But of course, you can adjust later on once the results actually come out. But no downward adjustment. On fraternity war, this is my suggestion. So impose preventive suspension, not as a penalty. So suspend all the members, officers of the fraternity, but not as a penalty, otherwise violate due process, but as a preventive measure. You can say that to prevent escalation of incident or violence, no, all of you are placed on suspension. So it's not a penalty, it's a preventive measure, and you can be questioned for that. On term limit succession, I think we need to support the LEB to tell our management the term limit of law should be 5 years, not 3 years, because 3 years is too short to measure the effectiveness of performance by law. So full cycle, 4 years, right? So 3 years only, that means that your top student, your students, you recruited in your first year, will take the bar 2 years after your term ends. So your performance will only be gauged now after 4 or 5 years. And then get your senior faculty expert, identify and train prodigy, I think I have mentioned that. Performance in the bar exam, job opportunities for graduates, solution, all of the above I mentioned, and then be active in PALS.
Yes, that's a very nice idea.
Alright, the vision challenges. Number 2, how do you manage English Slack enrollment by 2020 due to the K-12 education program? As you all know, because this K-12, you have additional 2 years for high school, right? That means you have no first and second year by 2020. So all of us will have no first year and second students by 2020 unless we do something about it. Suggestion, have 5 to 6 year programs. 5 to 6 year programs to make up for the slack. And then intensify recruitment from the pool of working students. I'm sure there are many working students, right? You'll be affected only by the incoming freshmen. But there are many working students out there, so be active and intensify recruitment efforts. And then offer advanced law course to senior high school students with assurance that they should be credited once they enroll in law school later on. On social media also, this is my suggestion. If you cannot lead them, join them. If you are a friend to all your students, they will think twice before they hit you. Right? But how to be a friend? You be as liberal as possible, do it. When you're busy, get your secretary to do it, no? So be a friend of your students, no? But of course, be objective. You have to be a friend only in social media, but you have to be a mentor when it comes to giving grades and imparting education. On copy, on requirement of obtaining master's degree, solution for discussion with the LEB. Next, please. No challenges are insurmountable, right? So if you're committed, if you want to succeed, then nothing is impossible. If you set your mind on it, it will be achieved. And PALS, next slide please, PALS, LEB, and IDP are here to help you face up to the challenges. Let me end with a quote from D. Raul Pangalangan, now Justice or Judge of the International Criminal Court. He says, he who can acts, he who can do more teaches. Let me add my own. He who inspires leads. So may we continue the inspiration to our students. Thank you.
The focal points of my assignment and address issues on the state of our legal education system and its import to the standards, ethics, and professionalism of the legal profession, shorn of roughs and frills, in commentaries thereon. In 1997, in an article by Professor Flerida Ruth Romero, who later became Associate Justice of the Supreme Court, she quoted an assessment of the state of our legal education, which came out at the Law Deans Conference in 1976, that says, our legal education needs upgrading, and therefore, she recommended the adoption of the following proposals. Number one, the administrative supervision, which was then lodged in the Bureau of Higher Learning in the Department of Education and Culture, be transferred to collegial body, a committee composed of representatives of the Supreme Court, the DepEd, the law schools, the IBP, and the public sector. Number two, for the undergraduate degree required for the studies of law, 2 years of formal preparatory education will suffice, while the third and fourth years be devoted to first-year law subjects. In effect, she proposed to bring down the study of law from 8 years to 4. Number 3, revision of the curriculum to make it more relevant and responsive to the needs of society, and to better equip the students for the broad and multifarious demands of the legal profession. And number 4, the abolition of the bar examination at some future time upon the institution of a practicable alternative. In the meantime, the system stays, but guidelines should be formulated for the bar examination, whose major concern must be to test the intellectual capability and powers of analysis of the examinee. The first proposal was met positively with the creation of the Legal Education Board in 1993. The second recommendation did not shake concern at all. The third proposal should be read in conjunction with the second recommendation. Nevertheless, in 1992, the Supreme Court made the requirement for law studies a preparatory degree with a list of subjects as major or field of concentration that included Spanish. This is Rule 138, Section 6 of the Revised Rules of Court. It has prescribed for graduation in law school and admission to the bar examinations the completion of the courses on civil law, commercial law, public and private international law, political law, labor and social legislation, medical jurisprudence, labor, taxation and legal ethics, which subjects have remained the contents of the bar exams. Except for the bar exams in 2011 to 2013, which carried the multiple choice and memorandum or MCQM format, the bar exams have gone for the various types of testing capabilities, but excluding the MCQM type. At this juncture, I'd like to pose the question, is our legal education any better after the appraisal made by Professor Romero in 1977 and at the Law Dean's Conference in 1976? I reckon with my conversation with Dean Marilyn Magallona the other day in the boardroom of the IBP, together with Dean Silvery Candelaria. We were having a meeting of the IBP Journal Board of Journal. And according to Dean Marilyn Magallona, who was a member of a project in 2004, which made a survey on the state of our legal education, Dean Magallona said that our legal education system is a big picture of devastation. The phrasal noun reminded me of the destructive earthquake that recently rocked Kathmandu. In more recent time, Dean Mariano Magsalin of the Arellano University made a similar biting assessment of our legal education system and endorsed a radical restructuring of the Philippine legal system, characterized by its inordinate bias to the bar exams, lack of honest-to-goodness implementation of a law school accreditation system, lack of investment for faculty development, poor facilities and outdated technologies. Particularly, he scored against the lack of centralized law school admission tests in the country, unlike in the United States, which an applicant will have to hurdle before being admitted to a law school. Law schools in the Philippines conduct their own admission tests. Only some schools maintain strict admission policies and instructions, while others observe the opposite with strict retention policies. The study of law is an exacting work, but Dean Magsalin observed that there are more working than full-time students. Lack of qualified and full-time faculty besides to our legal education, noted Dean Magsalin. Most law schools are in the provinces and far-flung areas that are in dire need of good lawyers, but many of the great minds of the legal profession are concentrated in Metro Manila and other urban centers where the pastures are greener, so to speak. Perhaps there may be more weaknesses and inadequacies in our legal educational system. One may hazard a well-considered opinion that the problems are as many as there are law schools, which numbered more than 120 now. To the question, has the legal education obtaining in the country conducive to professionalism, high standards of legal practice, and ethics in the legal profession, you have seen the big picture, and it's generally a disorderly collage. In other words, it's a jumble of source code which does not respond to commands, or when it did, it would give a messy output. The national passing percentage in bar exams paints a negative picture on our legal educational system. It has fluctuated from highs of 60.56% in 1977, 72.42% in 1953, 75.1% in 1954, to its lowest low at 16.5% in 1999. In most recent past, the percentage of bar passers has settled to about 20% or less than that. Today, we have about 56 lawyers, and 80% of bar examinees are bar flunkers. So if you round that up, the figure of bar examination attendees every year to 4,000 since 1980, for example, what figure would we have? It may be devastating to know that. I'm a private practitioner, and I have encountered lawyers with messy pleadings, not to mention their horrible English. In the IBP, the Board of Governors decide on the average 1,000 cases of malfeasance and misfeasance filed against lawyers every year. In the recent survey of the IBP on the internationalization of law practice and opening up the country to foreign lawyers, reaction was ambivalent, with only big law firms responding positively. The reason adduced by oppositors is the lack of competence for our lawyers, especially solo practitioners and those in smaller firms. But Chief Justice Maria Lourdes Sereno sees otherwise, noting our lawyers in international agencies and multinational corporations based in foreign countries are doing fine. Many of our law firms and lawyers too are correspondents of respectable foreign legal firms. Even from inside the country, they render counseling service to foreign legal firms and corporations on piecework transactions. Be that as it may, I believe that now, and I agree with Dean Leo Divina, that now is the most appropriate time to adopt reforms in our legal education system and raise the competency of level of all lawyers of the land to world-class and mold them into honest, fair, and leading partners in national development and globalization. It is time to breed a new crop of lawyers, not just the best, but good and Christ-like lawyers. Thank you.
To discuss problems of the past. We assess today the present-day concerns and challenges, all to the end that in the future, our legal education will be able to truly shape a nationalistic and a global Filipino law.